workplace practices. There's employment posters everybody's supposed to have. I always, I kind of assume everybody does that. I don't know if you guys get like 14 mailers in the mail every week. You are required to have posters, and if you do get audited or inspected by the Department of Labor, they do go look to make sure that they're there. Personnel files. Make sure they're kept up to date. Make sure you don't have medical information in them. You just have a separate medical file, because you just never know when that medical information might reveal a disability or might be the basis for a perceived disability claim or something. So supervisors generally should, just on a need-to-know basis. So job descriptions, I'm a big believer in job descriptions if they're done well. They really help with ADA claims. They help a lot with wage and hour claims, making sure our position's correctly categorized. But they need to be kept up to date, more so even than a lot of other documents. I recommend to my clients that if they do annual performance reviews, that job description be part of that performance review. That just makes the supervisor and the employee sit down, look at the job description. None of us are living in a static world. Things change a lot, and jobs change to meet those new demands. And so sit down at the performance review and say, yep, this accurately describes my job, or we need to tweak it here or there. Performance appraisals, once again, I'm also a big fan of those, but I have to tell you, if you've got supervisors, they just give everybody an A, well, that's going to haunt you. When it's going to haunt them when they come around and want to terminate that person, because they've got to justify it to a court. Why it is you want to fire this person when 2 months ago they were like your star employee. I-9s, make sure you have them, keep them for 3 years or at least 1 year after termination of employment. They should also generally be kept in a separate file because they do have some information on them that supervisors could use that tells discriminatory information. So you generally try to scrub all that stuff out so supervisors don't get to see that. Employee handbooks, personnel policies. I've been doing a lot of those. I don't know, that must have been on my client's New Year's resolution or something, which is good because there's been several law changes that really require almost all employee handbooks to be updated. If yours hasn't been updated in a couple of years, you probably need to have it updated. Both the EEO policy, FMLA policy, those for sure need to be updated just in the last couple of years. So your handbook should make sure that it's drafted well, that it has a very clear disclaimer that it's not an employment contract. Otherwise, there are a number of South Dakota cases where they've held that it is an employment contract and you're basically stuck with it until you can kind of work through that issue. This is my number one reason for having an employee handbook. So if you don't have an employee handbook, you should still definitely have every employee sign off on that sexual harassment policy. It is the cheapest form of insurance that any employer can have. Because without if you get somebody files a charge of discrimination against you and you don't have a sexual harassment policy, you are hosed. You don't have really any ability to defend yourself. So you want to make sure you've got a good policy, and it shouldn't just be a sexual harassment policy. Right after Clarence Thomas, that's what the courts were requiring, a policy that prohibited sexual harassment. Well, that's been expanded now, and it should basically prohibit any one of the protected characteristics under law, and have a definite policy for reporting it, who you can report it to, a couple of different people that it can be reported to, so they're not just stuck with the one person they claim is harassing them. And then it should have a very clear promise that they won't be retaliated against. All of those things need to be covered in it. Your handbook should also have, in this day and age, an electronic communications policy that very clearly says that if you're on our machinery or you're using your smartphone for our business, we have a right to go in and look at the emails that you're sending to see what you're doing. Otherwise, you don't want to get into a situation where you can't get in there because an employee's claiming, well, that's, I've got my own password to get into this, so you can't look at it. Frankly, most cases anymore, particularly employment law cases, a lot of the evidence at trial is emails, text messages, things that happen on electronic devices, and you need to be sure that you can get at it. You need to be sure that you can get in there and make sure they're not running off with your trade secrets, all of those kinds of things. But if you give somebody a password and you don't tell them that you still have the right to get into that information, courts will say they might have a right to privacy and that you might not be able to get in there. So that's important.